everyone. Welcome to Entrepreneurship in Plant-Based Drugs. Today we are going to look at intellectual property rights. What are intellectual property rights? Intellectual property rights are the ownerships or the rights given to an individual person or a company or an institution for their creation. A creation that is product of their intelligence or knowledge. IPR refers to intangible properties or creations that needs to be protected similar to other tangible physical properties such as your car, flat, etc. This usually gives the person or the inventor or the institution the rights to use that particular creation for a certain period of time or for an indefinite time. It gives the ownership of the particular creation or an innovation or a discovery to the individual who has put in effort and time and wisdom to create a specific product. How is IPR related to plant-based drugs? That is, inventing a new plant-based drug requires a lot of scientific investigation and also ownership of a particular innovation. IPR is very important for entrepreneurship. If we want to establish a new company or a new plant-based drug in the market, we need to have IPR for that particular product. So that will prevent the competitors or the other companies to copy your idea or to exploit your invention. The IPR has several types, but the three important IPRs that we are going to talk about are patents, copyrights, and trademarks. These three IPRs, intellectual property rights, are very important not just for pharmaceutical or plant-based drugs, for any entrepreneurship or for any companies or for any industries to be established. The company should have certain IPRs which makes them unique. Let's look at these three IPRs in detail. What are patent? Patent is a complete legal right or a legal ownership of an intellectual property. The intellectual property refers to an innovation in this particular case, in which the owners can be an individual person like a scientist or a company like an industry or even academic institutions like universities. But this patent is very specific, or it has a very unique feature, that is, patent is valid only for 20 years, beyond which the innovation can be used by others. Additionally, patent does not protect the innovation across the globe. It will give rights for an individual or an affiliation or a firm only for 20 years in a given country or in a given region. For example, if we apply for a patent in USA, then that particular invention is protected or is owned by the individual or the company only in that particular country. So depending on where the market for the individual product or the particular invention applies, you can choose to apply patent in different countries. However, you can also apply patent in multiple countries. That is, you can protect or you can own this particular invention in USA, Australia, India, UK, etc. But you need to apply and obtain the patent in individual countries according to their legislation. As I mentioned, patent applies only to innovations and not for discoveries. For example, people have invented that turmeric has an active ingredient called curcumin. That is a discovery. Finding what chemical is present in a plant, it's a discovery. However, if you use that particular curcumin or use that any specific compound for a medicinal application, then it can come into innovation or an application. So simply discovering that a particular chemical or a particular plant is present in a particular region does not qualify as an innovation unless you are applying the chemicals, or you're applying the knowledge you have gathered into a practically useful innovation, then only it can be patented. So, a patent is a legal ownership of an innovation for a period of 20 years in any given country. You have to apply for patent in different countries if you believe that there is a demand for your particular product in different countries. Next is copyright. Copyright is a different form of intellectual property, very similar to patent, but this need not be applied, or this need not be obtained from the legislation or from any government body. Copyright applies to creative works such as movies, music, books, etc. It does not require innovation, rather it requires creativity. Although it does not require a legal application and registration, there is a concept of registration of copyright which does not give the ownership, but it acts as a proof that you are the first person to create or to produce such quality of work or such type of work. For example, a musical album. In future, if anybody reproduces your work without your permission, the person can be prevented from reusing or copying your work. This does not apply for innovations. It can simply be a creative work or an artistic work, which includes painting, literature, music, movie making, book publishing, etc. So, copyright need not be applied. It does not have a duration of expiry and is not restricted only to a specific country. Next is trademark. A trademark is more of a sign or a logo that defines your company or your firm or institution. The best example would be the logo for Dell, Acer, Samsung, iPod, etc. The logo differentiates their company product from their competitor products. And a trademark needs to be registered. You have to register your logo or a symbol that defines or that represents your company or firm. And once trademark is obtained, your competitors are prevented to use that logo. This logo will stand as a quality or a representation or the standards of your firm or company. Similar to patent, this particular logo is also applicable or restricted only to a specific country. If you are applying for a trademark for your company logo, you have to apply it based on which country you are using that particular logo in. If your company is located in India, then you have to trademark your logo in India. If it is in USA, then you have to apply separately in USA. Likewise, whichever the country that you are trying to establish your firm, you have to apply for a trademark in that particular country. To apply for a patent, to apply for an intellectual property right, you need a proof of concept based on which your company is establishing. For example, let's say you have come up with a new plant-based drug which you are trying to establish a firm and you are trying to produce it in large scale and you are going to sell it to the public. How will you obtain a patent or an intellectual property right? What do you need in order to get an IPR? The best example is a patent. How will you obtain a patent? You need to provide a scientific evidence to claim that this particular plant is said to have the medicinal effects that you are claiming it to be. Let's say you are claiming that neem has an oral hygienic property, that it can kill all the bacteria in the mouth and it can help maintain an oral hygiene. For this, you need to provide scientific evidence. A scientific evidence can be used for any medicinal applications like antimicrobial, anti-cancer, antidepressant, anti-leishmaniasis, anti-malaria, anti-dengue. There is a lot of different pharmaceutical applications. Whichever is the application, you have to provide an experimental proof that this particular plant can work against this particular disease or disorder. The experimental proofs can be of multiple types. I'm going to discuss the three popular ones. One is in silico, in vitro, and in vivo. These are the three popular methods of providing proof that the said plant is having the said medicinal property. When you provide an experimental proof to claim that the plant is having this medicinal property, then you can apply for an intellectual property right, for which proof of concept is mandatory. So, if you are trying to apply for a patent, you need to prove that your idea is unique or nobody has proven this before. So, you're going to be the first person to test or experiment on this particular combination of plant and the disease. What are all these three different terminologies: in silico, in vivo, and in vitro? The types of experimentations include in silico, or silico refers to computer. So the experiments done using computers and using literatures, that is only based on previous information that is available from various sources, and based on computational analysis. There is a separate field of study called as bioinformatics, where people experiment using computational programs and they come out with new drugs just using computers. So in silico experimentation is a very solid platform which demands huge computational power and working knowledge. The next is in vitro applications. In vitro means cultured in a glass container or grown in a glass container. I'm sure you must have heard bacteria being grown in test tubes. Animal tissues like liver, kidneys are grown in petri dishes, and plants can be grown in culture flasks inside laboratories. So if you are testing, for example, you are taking the neem leaves and you are testing it against bacteria and trying to prove that the neem leaves are killing the bacteria using cultured, that is microbial culture or animal culture or plant culture, any of the cultures in a glass container, that will qualify it as an in vitro experimentation. The third is in vivo, also called as animal studies, which is popularly referred to as preclinical studies. These are experiments done on animals such as mice, rabbits, mouse, and fishes. This preclinical study, also called as in vivo or animal studies, is absolute mandate before going for human testing or human experimentation. The human experimentation is called as a clinical trial. However, that is not required for applying for a patent or applying for IPR. The proof of concept for applying for a patent can be based on any of these three methods or combination of these three or all the three included. So proof of concept will be stronger the more type of experimentations that you are including. A simple analogy, an experiment which includes in silico, in vitro, and in vivo has a very strong claim that it is having a medicinal property when compared to an experimentation which was done only using in silico. So for establishing a company, it is expected to have as much evidence as possible for the claim that we are making on a specific plant for its specific medicinal application. I hope this intellectual property rights and what we need to apply for these intellectual property rights is clear. We'll continue in the next video. Thank you.